you
This
very much for
conference
this
will now be
introduction.
recorded.
And thank you for the introduction, and good afternoon, ladies and gentlemen. Thank you for attending our presentation today on anti-bribery in the UAE and associated penalties and the impact of SAPIN, FCPA, and UK Bribery Act on companies in the Middle East. Can we change the page? Thank you. Next. Next page, please. Bribery is a key risk for companies. It's a worldwide issue. This is a map prepared by Transparency International, which is an organization committed to fight corruption, and which gives us a good idea of where the corruption is based and which are the less corrupted countries. Unfortunately, I cannot say that there is a country which is not corrupt to a certain level. Next slide, please. This page is cutting from the newspaper. And as you can tell, bribery is a two-way transaction. You would need a briber and a bribe receiver in order to have the elements of bribery. So if the supply side of bribery is cut, then the problem will be solved. And you would see that these cuttings are related to UAE companies or to issues abroad the UAE, but has some element with the UAE. One of the matters is about the former DR CEO who was accused of corruption, and the Court of Appeal has sentenced that person to 10 years imprisonment. Another case which you might have heard of is Rolls-Royce had agreed to pay a fine of 170 million to settle corruption cases against it, and those cases involved Rolls-Royce using facilitators to win certain contracts. And among the names that come up is Unaoil and Petrofac. On the Unaoil side, in October 2020, Bassel Jarrah, a former executive of Unaoil, pleaded guilty to offences in 2019. And he was sentenced up to 3 years in prison in London, in addition to other financial matters. Now, the CEO and the COO of Unaoil, which are the Saman and Cyrus Ahsani, the two brothers, are facing criminal prosecution in the United States because in 2019 they have pleaded guilty. So as you see, these are names that we know. These are companies that have presence in the UAE, although this is not related to the UAE. Another very well-known company is Petrofac. And very recently, in 2020, the Court of First Instance fined its sales manager, its worldwide sales manager, on corruption basis, because by paying or by bribing certain third parties in order for them to give Petrofac some contracts in procurement and construction, then Petrofac was able to generate $3.3 billion of projects. So that person has been prosecuted, in addition to others as well. In another case, in 2020, the Dubai Court of First Instance found that a Dubai manager at a government entity level was was penalized to pay 1,850,000 dirhams, and he was sentenced to 5 years in prison for accepting more than 1 million in bribes. And the purpose was to facilitate payment and to progress payment instead of the briber waiting for their turn to be paid. So as you can see, bribery is part of doing business, and although the UAE has been trying very hard to curb bribery, we will talk more about it as we go further. Can we please go to the next slide? Unfortunately, bribery and corruption are still quite common in the Middle East, in some Middle East countries. Despite the efforts of the local government, in these countries, kickbacks are kind of accepted as being part of doing business in these countries. But thankfully, in the UAE, this is not the case. Bribery is illegal. And over the past decades, the UAE has been making strides, not only in enacting laws that govern financial crime, enforcing such laws, creating specialized police units to deal with bribery and similar crimes, but also supporting the government atmosphere, transparency, introducing legislation which would limit concealing unlawful acts. The various bribery and financial crime law regulations issued by Financial Regulatory Authority, the enactment of strict banking policies, the corporate and auditing reporting obligations, the regulatory compliance with the companies law, and most recently, reporting on the ultimate beneficiary owners of 25% or more in corporate entities, in addition to the economic substance law and the vast amount of regulations, decisions, and other supporting decisions from the government are all working hand in hand in order to regulate and to minimize the effect and the impact of bribery. And from the list, you can see the list here in front of you, you would see the various laws that apply. Of course, it's not an exhaustive list, but you can see that the laws refer to gifts and bribery, refers to the UN Convention, which has been ratified by the UAE, and the gifts which apply to government and officials accepting bribes or accepting gifts which is only possible if it's a symbolic conflict of interest situation, the company's law which dealt with also conflict of interest and other compliance issues, etc. So from the list of laws, you can see that the UAE has been trying very hard to combat bribery. Can we go to the next slide, please? The main source of litigation which really curbs bribery and deals with it to a great extent is the UAE Penal Code. And the Penal Code distinguishes between an offense to the public and to the private sector. The main articles that dealt with bribery are Articles 234 and 236. And as you can see that these articles, or maybe the main issues that have been dealt with in these articles are that any public official or person entrusted with a public service function, or a foreign public officer or employee of an international organization or company who is directly or indirectly involved, requests, accepts, promises a bribe in return for a service, in return for performing their job or work, or in return of not performing their duties or their job, then that will be caught under the law. So also, any person who promises a public official or a person entrusted with a service, whether it's a foreign public official, it's an employee of an international organization, anyone who is promised such a bribe, whether directly or indirectly, in return for performing a specific act, would fall under the law as well. So therefore, in general, any person who acts as an intermediary as well, or facilitating a bribe, or a recipient of a facilitator, or offering, demanding, accepting, promising, all these would fall under the law. So if we consider the territorial reach of the law, it's quite wide, and whether the person who committed the bribe is a UAE national company, a private, public, movable, whether the assets related to bribery are movable or unmovable, if the scope includes any official, that would also include the court experts, the arbitrations, also experts who provide certain researches, or if a person is appointed by a government authority on a specific job to represent that authority, would also be caught under this law. So as you can see, the scope is quite broad. The consequences will be the seizure of the proceeds of crime, and in addition to fines and imprisonment, which we will talk about it later on. Further, one point to mention is that in the event of a bribery situation, there is no limitation period for criminal or civil actions brought in relation to bribery offenses. Next, please. So the question we would ask ourselves is, who would be considered a public employee? According to the UAE Penal Code, the public officials are mentioned under Article number 5, and it defines it as those who are in charge of public functions, members of armed forces, members of legislative and consultative councils, delegates by public authority to perform a specific job, members to board of directors, members to public associations and corporations, members to societies and institutions of public utility. So whilst the definition of public officer is very broad and vague, the Court of Appeal, or the Dubai Court of Appeal, has interpreted it to read as the public officer include employees of companies which are wholly or partially owned by a state. Well, this would have an impact on the example which I'm going to give you now, because the Court of Appeal, Dubai Court of Appeal, has found that if have sentenced, in fact, the chief butcher and the chief person in the kitchen of in Burj Al Arab on the basis that they are public officers because they work in an entity which is owned by Dubai government. And what has happened, these two individuals have been taking kickbacks from suppliers for around 900,000 dirhams on the basis that the food quality they are buying is at the highest level, where in fact they were replacing fresh fish by frozen fish. So it just shows that sometimes if a company is owned by or semi-owned by a government authority, then it will be regarded as an the employee will be regarded as a public employee. Can we go to the next page, please? So different treatment for bribery. There is a distinction between those who are employed by the public sector and those who are employed by the private sector. And I would like to take you to the, yes, thank you. So a public employee found guilty of soliciting or accepting a bribe would be subject to a fine equal to the bribe and confiscation of the bribe or the gift or whatever he has taken. And if it's property, for example, the return of that property, and then that person can face up to 10 years imprisonment. Now, if that person is a non-UAE national, that person would most likely be deported. Now, if the briber of a public employee, then that person, the briber, will be subject to a fine equal to the bribe offered and will be imprisoned up to 5 years and possible deportation if this individual represents a company or signs on behalf of a company or is dealing with that public officer. Now, consequences also that can follow due to that act is if there is a contract with the government department, then the contract will be terminated. There might be a seizure of performance bond. There might be a claim for compensation for the damages caused, and then maybe the license can be terminated. The consequences will be dire in general. And I would like to mention that facilitation payment is also criminalized under the penal code and under the relevant laws. So what is the exemption? Is there any exemption from criminal punishment? And the answer would be yes. The direct or the main exemption would be from a criminal punishment would be if the person promptly informed the authorities before the crime is discovered. And that is in accordance with Article 239 of the Penal Code. So can we go to the next page? Well, I'd like to talk about whistleblowing. Can we go to the next page, please? All right. So while whistleblowing is not protected at the federal level, Dubai Law number 4 of 2016 has some protection for whistleblowers in respect to certain financial crimes. There is, however, a general obligation under Article 274 of the UAE Penal Code to report a crime, and failure to do so is a criminal offense. So therefore, whether you are protected or not, a person must, under the law, report the crime. So also, a crime, if a person fails to report the crime, of whether it is money laundering, whether it is financing terrorism, bribery, or a criminal organization, or a crime related to any crime, then basically they can be caught under the penal code. However, DIFC law number 7 of 2018 sets out protection measures that apply to whistleblowers. The protection measures include in the operating law, and it applies to failure to make protecting those who are the whistleblowers. In fact, they should not be prosecuted on the basis that they have informed or disclosed information which is subject which may subject them to any legal or contractual liability, or subject to any other civil or any other remedy, or they may suffer as a result of this disclosure or consequence to the disclosure. Also, they cannot be dismissed from their employment because of their disclosure to the authorities. So DIFC law is more extensive with respect to whistleblowing, and hopefully this is something that the UAE would take on the federal basis and would apply it in the future. I just want to mention here that ADGM does not have the law on whistleblowing yet. UAE has issued several judicial precedents on bribery. Dubai Court of Cassation judgment number 238/2008. It stated that it is sufficient that a public official has relationship with or an interest in specialization which enables him to achieve the purpose of the bribe. Another court case found that the criminal intention in the offense of bribery is established upon the bribed person's knowledge, upon his request, acceptance of promise, grant, or benefit that he is doing so in exchange for the performance of an act or omission or breach of his duties. Another cassation judgment found the effect of Articles 234 and 236 read together is that it is not necessary for the establishment of the offense of bribery that the bribed official himself performs or omits to perform the required act. And you would see most recently appeal to number 306 of 2020, the UAE law. It is not a condition in the crime of bribery for the employee alone to be delegated to perform all the work concealed to the bribe. It is sufficient for him to be connected to it or has a certain ability which allows him to execute the reason behind the provision of the bribe. You would see here how the scope is quite wide. And in Appeal 672 of 2019, the crime of bribery is complete once the employee asks for the bribe or accepts it, whether the purpose for which the bribe is provided is legitimate or not. This is so since the performance of the purpose of the bribe is not a tenet of the crime. So this goes back to the example that of the employee example, where he was fined 1,850,000 dirhams. All he did is he accelerated the payment process in return for a bribe. So the party would have been paid. His company would have paid anyway. But the fact that he has been paid a bribe to accelerate payment resulted in him being prosecuted. Next page, please. You would see here where we stand. This is a chart which shows illustrates the vast importance and improvements that the UAE has done over the years, and you can see how the UAE have moved from 2010 to 2018. And I'm very pleased to say that its position in the corruption perception index score from last year to this year, of 2019, has ranked UAE as a number 21 globally, whereas the UAE is in front of the United States and France, which jointly are number 23. So UAE is doing great strides in combating bribery, terrorism, money laundering, etc. Yeah, we do still have 21 levels to go, but we are on the right track. And with all the laws that have been implemented in 2020 and the years before, we are doing very well. I would like now to move to SAPIN II, and tell you a little bit about it. SAPIN II was enacted for the purpose of preventing or issuing clearer rules to prevent and detect bribery. SAPIN II stipulates that companies must establish an anti-corruption program to identify and mitigate corruption risks, and companies may be held liable for breach of their requirement even where no corrupt activity has been taken. So this legislation provides protection to whistleblowers. In addition, SAPIN II has established an entity called National Agency for Prevention and Detection of Bribery to enforce SAPIN II. And by enforcement of the SAPIN II, this authority can find itself self-sufficient, because the companies who have violated SAPIN II would be paying this authority for a period of 5 years for this authority to supervise them and monitor them in order to ensure that corrective measures and improvements are really made. So if we go to the next page, please. Which companies will be affected by SAPIN? Companies that are headquartered in France, companies that have 500 employees worldwide, and their turnover is over 100 million euros. But this also applies to subsidiaries of foreign companies that have French subsidiaries in France. So therefore, the subsidiaries are also covered under this, under SAPIN II, if the company has more than 500 employees, as I mentioned. I would like to mention here that French courts are able to prosecute foreigners, usually residing in France, for bribery acts and influence peddling abroad. And this is abroad, because such individuals could be foreign directors of companies which are subject to French laws. Next page, please. So SAPIN II has extra-territorial reach, and this means that if there was a dual criminality requirement for bribery crimes occurring overseas, then that also could be prosecuted. So it is applying further strength and further rigid requirements on corporates in order to ensure that they don't bribe or be bribed outside France, in and outside France. So what are the next page, please? Yes. What are the offenses? I've listed here the offenses, but due to the time constraint, I will just go through them very briefly, and you can read them later on when this is shared with you. There is the passive corruption, active corruption, bribery of foreign public officials, trading in influence, peddling, and the commercial bribery. Can we go to the next page, please? So the defining feature of SAPIN II is that it can hold companies liable for failure to implement an efficient anti-corruption program, even where there has been no bribery or suspected bribery. In order to comply with SAPIN II, a relevant company must adopt a code of conduct describing the behaviors likely to constitute a bribery. This should be adapted in accordance with the company's particular activities and give some clear and practical indications or guidance to relevant to the company and relevant to the employees. Then set up a whistleblowing system allowing the employees to report behaviors or situation which breach the internal code of conduct. The whistleblowing system should be defined, should define the process allowing employees to report such behavior and without any consequences and without any consequences on the employees who would do so. Also, create a risk map, ranking and classifying the company's risks of exposure to corruption by sector, by geographical area. Run a due diligence on the company's major clients, suppliers, and intermediaries. This is very important because even if the supplier or its clients or intermediaries are involved in bribery, then they may find themselves involved in bribery without them knowing. And a good example is Petrofac. Petrofac UAE did not know what Petrofac head of sales was doing in the UK, and therefore the consequences were the shares of Petrofac were affected by the acts of their head of purchasing or the person who was prosecuted. And it is good to adopt a code of conduct describing behaviors that may constitute bribery acts, and set up a whistleblowing system, allowing employees. I think I'm going through the same page. Am I not? Can you please? Yeah, thank you. Implementing internal and external accounting and auditing processes in order to ensure accounting books are used not to conceal corruption or influence of peddling acts. Train the employees to identify risk elements and to bring it up whenever they feel that there is a need to say so. Set up a disciplinary process that enables employees to identify the processes, and set up internal processes to control and evaluate measures implemented. Next page. So what are the penalties for a legal entity? A fine of up to 1 million euros per occurrence. For natural persons, that would be up to 200,000. For natural and legal persons, for peddling, that would be 5 years imprisonment plus a fine of up to 500,000 euros. Next page, please. And now I would leave you to Ruby, who would take you through the UK and Bribery Act and the US as well.
Great, thank you, Rita. Okay, so I'm just going to walk you through very briefly the UK laws and the US bribery laws, with a focus on how these laws may impact entities based here in the UAE. So starting with the UK bribery law, the laws are governed by the UK Bribery Act of 2010. And the first question to sort of contemplate is, who does this act apply to? So it applies to any company that is registered in the UK. So if you are dealing with a company that has operations in the UAE, but it's actually registered in the UK, that company will be caught by the UK bribery laws. So likewise, any foreign registered company, so any company that's registered here in the UAE or Dubai that has an operation in the UK will also be governed by the UK bribery laws. That's quite important to bear in mind. So senior officers of those two sets of companies will also be individually criminally liable where they have knowledge or they have consented to the bribery offence. So that's very key to understand and to sort of to put into your risk assessment for anti-bribery offences. So who are senior officers? Senior officers are broadly defined as directors, managers or secretaries of companies that are caught by the UK Bribery Act. But note that the senior officer must be a British national or an individual ordinarily resident in the UK in order to be caught by the Bribery Act. So if you could just move to the next slide, please. Okay, so we're looking here at extraterritorial reach. So does the UK Act have extraterritorial reach? Yes, it does. There are no territorial limits imposed on the UK prosecuting authorities in relation to the prosecution of a UK corporation, a UK partnership, a UK citizen or resident. And non-UK persons can be prosecuted for bribery offences where any part of that bribery offence takes place within the UK. So if somebody travels, a UAE resident or UAE entity travels to the UK and commits a bribery offence there and returns back to the UAE, they are still caught by the UK bribery laws. The next slide, please. So this slide sets out the four offences under the UK bribery law. The first two are fairly self-explanatory, so it's just the offering and the accepting of a bribe. And note that these apply to both public and private functions and can also apply to indirect bribing or acceptance of a bribe. There is a separate offence for bribing a public foreign official. And then there is the what we call the Section 7 offence. So Section 7 of the Bribery Act states that a company that fails to prevent an act of bribery can also be liable under the UK Bribery Act, and that's quite interesting. So Section 7 says that a commercial organisation will be guilty of an offence where it fails to prevent an associated person from bribing another with the intention of obtaining business or an advantage in the conduct of business for that organisation. So what is an associated person? An associated person is defined very broadly, intentionally broadly by the Act, and it includes employees of the company, agents of the company, and also subsidiaries. And I'll talk you through a case study, or it's an actual, it's the first case that was ever heard under Section 7. So if you can just move 2 slides across, please. I think I'll just skip the next slide in view of the time. If you just go to the case study, please. Yeah, so we'll skip this one. If you just go to the next slide, please. Thank you. So on this slide, I've set out a really interesting case with a UAE connection. So in summary of this case, a UK construction and professional services company called Sweet International Limited was fined £2.25 million under Section 7 of the Bribery Act in 2016, even though Sweet International Limited itself had never offered or accepted a bribe. So what had happened is Sweet Group's subsidiary company, based here in the UAE, offered a bribe to another person in order to secure a construction contract for building a Rotana hotel in Abu Dhabi. And as a result of that bribe being paid in the UAE by the subsidiary, the authorities prosecuted the parent company in England. So that sort of highlights how important it is for companies affected by the UK bribery laws to ensure that their associated persons, which includes subsidiaries, do not commit acts of bribery on their behalf. And I won't go through all of the details of that case, but it is a really interesting case study if you want to go through it in your own time if it interests you. Could we please move to the next slide? So here, Section 7 under the Act, as I said, makes it an offence for an associated person to commit an act. Sorry, it makes it an offence to prevent an associated person from committing an act of bribery on behalf of the company. But there is a defence where the company has adequate procedures in place to prevent associated persons from committing that act of bribery. Now, the Act does not describe in detail what those adequate procedures are, so it is a sort of case-by-case assessment, and each entity affected by the law should keep clear documents of how they are actively preventing people from bribing on their behalf. And not only should they have a sort of anti-bribery policy in the company, but it also has to be actively implemented throughout each of their subsidiaries and with each of their agents and anybody that might be considered an associated person. So that's at least there is that defence there. So if we could just move to the next slide. The next slide sets out the penalties, and you'll see that the penalty can be quite severe. There's no limit to how much the UK authorities can fine entities for breaching the bribery laws. And if we move to the next slide, we've set out quite a helpful illustration. On the next slide, please. There's a helpful illustration on the next slide which shows that the cost of the bribery offence is more than just the fine. The fine is just the tip of the iceberg, but then entities will have to pay for the investigation costs. They'll have to pay for the forensic accounting costs, they'll have to pay for the legal fees, their contracts might be suspended pending the outcome of the bribery investigations, and there's obviously unquantifiable reputational damage as well. So it is a serious issue for all companies caught by international bribery laws. So if you could move to the next slide, please. I will start to talk you through the US laws and how they may impact UAE entities. So the US laws are governed by the Foreign Corrupt Practices Act, and this applies to two separate types of entities. The first type is those with formal ties to the US. There's two categories or subcategories of persons or entities with formal ties. They are referred to as issuers and domestic concerns. So issuers are companies that have securities registered at the US Stock Exchange, or companies that are otherwise obliged to file periodic reports to the Securities Exchange Commission. And any officers, directors, employees, agents, or shareholders of issuers fall into that category. The second category of those with formal ties to the US are domestic concerns, and this encompasses pretty much everybody else. So individuals who are citizens, nationals, or residents of the United States, and any other sort of US entity. So it could be a partnership, an unincorporated association, a sole partnership, or a business trust, for example. They will all be caught by the definition of domestic concern. The second category of persons who the FCPA applies to are those who commit an act of bribery in the US. So that could be any UAE entity or person committing an act of bribery while in the US. So if we move to the next slide, I can put that into context for you. The next slide. So on this slide, you can see here that the FCPA has extra-territorial concerns. They can be caught by the FCPA where a bribe is paid to a public official, even where the related decision or action has not taken place in the US. So if there are any persons or entities that are fall within the definition of issuers and domestic concerns, committing or deciding to commit an act of bribery while in the UAE, they are still caught by the FCPA. The FCPA is taken to confer jurisdiction wherever a foreign company or we're still on the previous slide. So the FCPA is taken to confer jurisdiction wherever a foreign company or a foreign national causes an act to be done within the territory of the United States by any person acting as an agent of that entity or that national. The FCPA also applies to foreign persons and foreign non-issuer entities that engage in any act in the furtherance of a corruption payment while in the territory of the US. And also officers, directors, employees, agents, and stakeholders, I think I should say, acting on behalf of such persons or entities will also be subject to the FCPA jurisdiction. Now, what's interesting about the US laws is that the laws do not expressly provide that a parent company will be responsible for the actions of its foreign subsidiary. So that's very different to the UK law. However, my understanding is that the US authorities will find creative ways to hold parent companies responsible for the actions of their subsidiaries abroad. So it's always better to be cautious. And if you could move to the next slide, please. I've set out here the 5 elements of the offence for there to be an offence under the US laws. I won't read through them now in view of the time, but they're there for your reference. And if we then move to the next slide, I've just highlighted some interesting points about the US law here. The fact that there is no threshold for the monetary value of a bribe. So perhaps a bribe of $10 or even a bribe that has no monetary value can still be caught by the US bribery laws. And the definition of a bribe provides that you don't actually have to have paid or accepted a bribe in order to be caught by the Act. If you have just agreed to accept, or if you have offered a bribe, you will still be caught by the FCPA. And then we can move to the next slide where we have the penalties under the US law. And then the next slide has a sort of an overview and a comparison of all the jurisdictions we've talked about today. And then if we just move to the penultimate slide, we can just skip the other two in view of time, where we have the key takeaways. We've just set out here for your reference key takeaways that you can use to review your own anti-bribery compliance laws. If the next slide, please. So that's just there for your reference. It loosely follows the recommendations or the requirements under SAPIN in order to just control bribery within companies. And you can see the slide that we do have on the board just highlights where bribery is more prevalent. So where you have cross-border jurisdictions or you have a fragmented contractual chain, those are the sort of times where we find that there's more scope for bribery to go unseen by the more sort of seniors in the chain of business. So that's just there for your reference. I appreciate that was fairly quick, but in view of the time, I've just sort of skimmed through some of the points so that we have a bit of time for questions. So thank you.
Thank you very much. Thanks for the insight, Rita and Robbie. As we said earlier, I mean, this is very, I would say, touchy subject because different cultures or different nationalities, different company ethics and other things could read different way for people, and we need to be aware of the subsequence of these things that we may be responsible for it and how we do, and a lot of these things should be clear, whether it's internal within the organizations through communications, through follows these procedures, or if it's anything external also, because they will be dealing with stakeholders, they will be dealing with other people, vendors, such as vendors and suppliers and so forth. So it has to be very clear and very transparent, so people know how to follow and understand different companies' responsibility, different companies' governance, regulations, and so forth. So we've got few questions we received before the event, and I'll take these questions that I've taken in the chat box. So we've got, is nepotism also considered as a bribe?
Sorry, Rita, your microphone's on mute. I'm not sure if you want to answer that one.
Yeah, sorry. Can you please repeat the question?
Yeah, is nepotism also considered as a bribe?
Well, the penal code is quite broad, and I would say anything which falls, which is illegal, is covered under the penal code. So I would say you have to be very careful.
Yeah, and under the UK laws and the US laws, if somebody is using their position of power to obtain an advantage for a company, then that could very much so, that could be caught by both the UK and the US laws.
Okay. And in terms of the practice, I mean, is it always advisable for contracts or for anything like that have to have this kind of a clause or information in it, so people, the parties, they know about it very well?
Ruby, do you want to answer?
Yeah, fine, yeah. Particularly for the UK laws, it's particularly important because, as we sort of said, I think in this region, gifting is quite, is the cultural norm, and it may be seen as a bribery offence under the UK law. And as we saw in the Sweet Group case study that I skimmed through, the parent company was held responsible for the acts of its subsidiary. And if there had been a very strong anti-bribery compliance policy implemented, and if it had been communicated and documented to all of the suppliers and agents, then they would have likely had a defence to that claim. But because they didn't have that available as a defence to them, because they hadn't put these clauses in all of their contracts, they were then liable for a £2.25 million fine. So it can be really important if you're affected by the UK laws particularly.
So it's all about the company. They have to define if these gifts has to be taken in what capacity and approvals and maybe recording it and things like this, right?
Right.
Yeah, well, the UAE law on the gift side and states, especially for the public officers, that the gift, if the gift is from a company with a company logo and name and so on, then that could be permitted for them to take it, because it is a nominal gift. It's not a valuable gift. So if it's a pen and the pen has inks on it, then that's fine, I can give it to you. And at the same time, if an authority was to give me a gift for, let's say, DP World is doing a New Year gift and send us a calendar or an agenda, as long as it has the name of the authority, the proper process has been followed and authorization has been taken, then that's, of course, that's not a bribe. That falls under the business development, or each company would have its own threshold. What is a gift and what is exceeding a gift? Is 50 dirhams exceeding a gift, or is it within the threshold? So that's something that each company would have for its own purposes. But for the but it's more rigorous for public officers than private companies.
I think it's probably important for companies to sort of consider which laws are applicable to them. So if they are captured by the US laws, then they should implement that into their policy. Because under the US laws, there's no threshold, right? But if it's the UK laws or the French laws, they should consider what is allowed under the laws applicable to them and design the policy accordingly.
Okay. So we've got another question. It says, what should the small companies do when they're faced with bribe as an option? If they refuse, how do you mitigate, and how do you handle such event?
Well, of course, any company, small or big or whatever size, should refuse bribery. It's not something that the company will take lightly, because at the end of the day, it could be the end of that company, especially if it's a small company. Imagine a small company slapped with millions of dirhams as a consequence, or as a compensation, or as a penalty. They have to be very vigilant, and the law is very clear.
Mm-hmm. So more and more of maybe awareness should happen within companies. So because as I said, the staff or the employees might be coming from different places, from different understanding. Some might not know the differentiation, as you mentioned, if it has a company logo, if it's in this way or that way, and if it's considered not expensive. There is a lot of perceptions there, so it has to be more of a clear. I mean, the more transparent, say, I've seen some companies in their reception says, we don't give gifts and we don't take gifts. So I've seen to that level also. That's very clear. It doesn't matter what kind of gift. If it's a $1 item or it's a $100,000 item.
Yeah. Well, that's where companies should really ensure that their staff are aware of the consequences of their acts. So if I go to a client and take with me maybe a pen with ink and say, this, whenever you write in it, remember me, then it doesn't cost 10 dirhams. I'm not bribing. But if I go to a customer and send them to Maldives, the husband and wife and his 6 children on the account of the company, of course that's bribery in disguise. So it depends on how it is packaged, but the employees should know, and this is why under the SAPIN laws, it is very important that the companies educate their employees, and in order to know when they should be vigilant and when the red lights should work, and they must have a reporting structure in place without fear, without being afraid that if I reported, my boss will not be happy with me and there will be consequences against me. So that protection would give the employee comfort that if that person comes forward when they see something wrong, then they are protected, and in fact they protect their own company.
Yeah. All right. I think we went out of the time, and very much appreciated Rita and Robbie for your participation today and for the attendees. And we look forward to our next event on digital transformation webinar on 24th of February next month. And meanwhile, next month one of our leading activities, they're participating in Gulf Food. So please follow us on the social media to understand what we're offering and what is there in terms of people who are interested in the food sector. So thank you very much, and stay safe.
Thank you. Well, if I can add that if anyone has questions for Ruby or for me, please send us an email and we'll be happy to answer your questions.
Thank you.
Thank you so much.
Thank you.
Thanks,
Thank
Thank
you.
you, everybody, for attending.
Thank you. Bye-bye.